one of the most far-reaching powers in recent years with major implications for civil liberties, which many believe would be unthinkable outside a major public crisis, is the power to quarantine potentially infectious people under Schedule 21 of the Coronavirus Act 2020. While this power has been rarely used, if at all, with more community testing of COVID-19, the use of contact tracers, contact tracing apps, with the aim of preventing a COVID-19 outbreak, it may well be that Schedule 21 power to quarantine will be more and more used by public health officers where people are not complying voluntarily with national and local regulations or guidance. Schedule 21 power to quarantine could be used if you are a potentially infectious person and fall into one of three groups. 1. A person who is infected with coronavirus. Or 2. A person who may be infected with coronavirus. Or 3. You have come to the UK from an infected area in the previous 14 days. Schedule 21 power to quarantine can only be used against you if there are reasonable grounds to suspect you are a potentially infectious person. For example, you've been reported as a person with COVID-19 symptoms such as a new persistent cough, or you've been identified by a contact tracer or an app as living with or coming into close contact with someone with recognised COVID-19 symptoms or who has tested positive. Or you've completed a passenger information form and have returned from a country which has a high infection rate and therefore you should be self-isolating. Schedule 21 power to quarantine are exercised by public health officers who are appointed by the government, who work alongside police and immigration officers. Schedule 21 power to quarantine grants three sets of powers to public health officers. Firstly, public health officers have the power to compel you to attend a place suitable for screening and assessment, which could be a secure hospital facility, and remove you to that place using police officers. Secondly, public health officers have the powers to detain you for up to 48 hours for screening and assessment at that secure hospital facility, for example, and compel your cooperation with that screening and assessment process, which could include to take biological samples from you to test for COVID-19, or to demand answers from you about your health, your movements and contact. Thirdly, public health officers have the powers to impose requirements and restrictions following your screening and assessment where you've tested positive or the results are inconclusive or they still suspect you have COVID-19. Requirements on you could include requirements to continue to answer questions about your health or who you've been in contact with, and to remain in a place like that secure hospital facility, forced quarantine, or your home in isolation, self-imposed, for a period of up to 14 days. Restrictions imposed on you could include restricting your movements or travel within or outside of the UK, going to work, a restaurant, a pub, or a place of worship, or restricting contact with family, friends, work colleagues, or vulnerable groups. In short, you could be required to remain in self-imposed or forced quarantine for 16 days and even more if the public health officer suspects you are still potentially infectious person. There are safeguards. Safeguard 1. The power to quarantine can only be used during a transmission control period where the incidences or transmission of coronavirus constitutes a serious and imminent threat to public health. This was declared by the government on the 20th of February 2020. Safeguard 2. Schedule 21 power to quarantine can only be exercised against you if it's necessary and proportionate for the protection of other people for the maintenance of public health. Safeguard 3. Public health officers should provide you with written notices of the powers being exercised against you, taking into account your mental health, well-being, giving reasons why you have been detained. Safeguard 4. Public health officers should give you a notice to appeal against Schedule 21 powers to quarantine so you can appeal your forced detention and compulsion to answer questions and restrictions on movement. And Safeguard 5. And remember, at any time the public health officer assesses you as not being potentially infectious, whether during that initial 48 hours of assessment and screening or afterwards, you should be released immediately from any detention facility restrictions or requirements. When it comes to children under the age of 17 or under, Schedule 21 powers to quarantine may only be exercised in the presence of you as the parent or guardian having responsibility for that child, or in exceptional circumstances those powers can be used If there's no such adult present and a public health officer considers it appropriate to use another adult, such as a social worker, local authority key worker, relative, or foster carer, having regard to the views of the child. Remember also there are a number of offences connected with Schedule 21 power to quarantine, and these are failing to comply with restrictions and requirements imposed by the public health officer, 2. Absconding from a secure hospital facility, 3. Providing false information to the public health officer, and 4. Obstructing a public health or police officer in the exercise of these powers. All criminal offences are punishable by a fine of up to £1,000. Thank you for watching. Please subscribe to Community Legal Education so you can be the first to watch an emergency coronavirus law series and other legal video explainers. Please speak to a solicitor if you need legal advice, and may the justice be with you.